Masechet Shevuot Daf Lamed Aleph Siman Sanegoron Bur Gezelat Mirma. We're about to see 13 laws that derive from this pasuk Midebar Sheker Tirhak. Not only that you're not allowed to lie, certainly you can't lie, but you have to stay away from anything that even looks like it might be a false matter. This is picking up on what we saw on the previous daf, where a judge should not have one litigant standing and one litigant sitting. Even if the judge is being fair, and one is a Tamid Chacham and one is not, but still, it doesn't look fair if looks like he's giving preferential treatment. So even if he's not, he's being fair, still, you have to keep far from anything that looks like it might be showing favoritism. So here we go. Tenor Banan. Minayin l'dayan shelo ya'aseh sanegoron lidvarav. Tamudoma midabar sheker tirchak. How do you know that a judge should not act as a defense lawyer? Sanegorin is a Greek word. That means a defense lawyer. The judge has to be impartial, equal to both sides. He can't act as a defense lawyer, constantly pushing one side and going against the other side. How do you know that? Because the pasuk says, distance yourself from a false matter. The judge shouldn't look like he's a defense lawyer for one side, even if he happens to agree with one side more, but he has to ask questions equally on both sides and be careful not to just accept one side and not the other and look like he's being paid by one side. So he cannot act like a lawyer. And the judge should not have a student who is an ignoramus sitting in front of him, because the ignoramus, the student is going to be asking questions that are not relevant, and it's going to distract the judge from concentrating, and then he might come to error. So stay away from a false matter, far away. Don't have a student who's going to distract you around by his foolishness. How do you know that a judge who has a colleague who he knows is a robber, or a witness there's another witness and the other guy is a robber? How do you know you should not join him? So even though the judge himself is honest and he's joining together, okay, well, I have to check all the other judges that I'm sitting with? The answer is yes, because even though you're being honest, but that guy who's a robber is not trustworthy, and therefore you should not even associate with them and sit on the court together, nor testify together with someone else. And we know that from the same pasuk. So, like if you're going to be a witness at a wedding or something, you say, "Who's the other witness?" If you know that the other witness is someone who's a robber, then you say, no, I don't want to be a witness together with that guy, because you associate with them. How do you know that if a judge knows that there's a judgment coming and the verdict is fraudulent, but he says, listen, it's not my problem, the witnesses came. The witnesses, I think they're lying, but they passed the test, I asked them questions, they lined up, they matched each other. So the judge might think to himself, I'll decide the law according to the normal procedure. I'm following all the procedures, and okay, there are two witnesses and we tested them out, and so I'll decide that, the person is guilty based on the witnesses, and let the witnesses be responsible. Let the chain be on their necks. This is from Roman times, a chain that they would put around criminals to mark them so they couldn't run away. You'd be able to know who they are. So let the guilt be on the witnesses. It's their problem. They came and testified falsely, so it's not my problem. No, that's not true, because you have to stay away from false matter. Even though the judge is following the regular procedure, that's fine, good. But if he suspects that there's something going on, then he has to dig deeper, ask the witnesses more questions, go do an investigation, figure it out. If you think that your verdict is wrong, then don't give that verdict. Sit there and spend extra time and go beyond the letter of the law, beyond the normal procedure, in order to discover the truth. Siman telata tamid utelat ba'alechov semartut shomea umata'im. Mnemonic for the rest of the laws here. Minayin letamid sheyoshev lifnei rabo v'ro'eh zechut la'ani v'chob la'ashir minayin shelo yishtok tamud lomar v'debar sheket tirhak. Let's say you're a student and sitting before one's master, and the master is judging a case, and the student sees sees, you know what, the master, he seems to be going like the rich person. He happens to think the rich person is in the right in this case, but the student sees a reason to find merit with the poor person, and that the rich person is actually guilty. How do you know that the student should not be quiet? The student might be thinking, listen, I don't want to embarrass my teacher. I don't want to show favoritism to the rich person. I'll just be quiet. I'll tell my teacher after. No, the student has to say, if he sees something that's wrong, you can't let it happen. You can't let injustice happen. Truth is, it doesn't matter which way it is. It doesn't matter if he sees merit for the poor person or the rich person. It's more likely that he'll be scared to say something if the rich person is the teacher is favoring the rich person. So the student might be embarrassed to say, I don't want to be in this bad side. I don't want to embarrass my teacher. No, you have to tell the truth, and therefore stay away from false matter and tell the teacher, hey, a question here, maybe you could think of this argument. שלא יאמר אמתין לו עד שיגמרנו ואסתרנו ואבננו משלי כדי שיקרא הדין על שמי תלמוד לומר מדבר שקט תרחק. And how do you know that a student who sees that his teacher is making a mistake as the judge, that the student should not say, I'm going to be quiet and I'll wait till my teacher finishes the trial and then I will come and save the day. And I will say, wait, I want to reopen that trial. My teacher missed a source, he missed a fact, and really it's totally different. And then I'll overturn the case and I will get credit for it. Everybody will say, didn't you hear the student? Right? He overturned the case and the teacher made a mistake. And so he wants to build up his own reputation by taking advantage of the fact that he knows something and he's not telling his teacher in time. Don't do that, because you should stay away from a false matter. And if you know there's something false going on, don't wait till later. Rather, tell the teacher in a respectful way, teacher, doesn't it say in this source that this and that? And the teacher immediately will realize, I made a mistake. Okay, and fix it on the spot. And it's also not right for the student to cause his teacher embarrassment just to take credit for himself, to uphold his own glory. So it's wrong on multiple levels, including the fact that he's allowing a false matter to go ahead for a while, and just because he wants to wait to take credit for fixing it himself. Why? This How do you know that if a teacher tells a student, listen, he tells a student, you know me, that I'm totally honest. Even if someone were to give me 100 maneh, I would never lie. Now listen, I'm telling you that guy owes me a maneh. But I only have one witness. So, student, would you mind joining him? You're not telling a lie, because I'm telling you that what you're going to say as testimony is in fact the truth. He really does owe me a maneh. So just testify, even though you didn't see it. But you trust me that it is true, and I have one other witness, so just join together. Can you do that? The answer is obviously not. You have to stay away from a false matter. Even if you trust the teacher and believe him he's totally honest, still, you can't go in court and say, I saw that he lent him $100 and didn't pay him back. You can't say that because you didn't see it. Now we ask, wait, this is not a problem of staying distancing from false matter, like it's over and above. This is outright lying. And the Torah says outright in the Ten Commandments, do not be a false witness against your neighbor. So this would be totally lying. So obviously this is not allowed. It's not just a precaution. תהה למהפכת מפומח שקרה אפילו הכי עשו משום תאמר ודבר שקט תרחק. Rather, we're going to give a new scenario that's less severe, but still not allowed. For example, the teacher says, you know me, I'm trustworthy, I'm totally honest. This guy owes me $100. However, I only have one witness. So why don't you, student, just go and stand there. Don't say anything. Just join him as a second witness, but you don't have to say a word. So you're not going to lie. You're not testifying falsely. Rather, you're just standing there to make it as if you're the second witness, even though the other witness will be the only one talking. So you might think that you could justify this because the student will say, well, I'm not actually lying. I'm not saying anything. I'm just seeming like joining the other witness. But really, I think this is true because the teacher is totally honest. No, even that is not allowed because it looks like you're saying something that you don't actually that you cannot actually testify about, and so you should keep far from false matter and don't even do that. How do you know that if someone owes someone else $100, that the person who's trying to collect should not do the following? He shouldn't go and claim 200, even though he really is only owed 100. He wants to claim 200 in court so that the other guy will admit to half and say, oh, I owe you 100, but not 200. I only owe you 100. Now, if he does that, that would be modeh b'miksat. And the law is that modeh b'miksat, someone who admits to partial payment, has to make a vow in court that I only owe 100, and the other 100 that you are claiming, no, you never gave that to me, I don't owe it to you. Now, here's why the claimant is doing this. The claimant wants him to make a vow about a different matter for which normally he cannot make him take a vow. However, there's a concept of gilgul, which means that if I bring you to court and make you swear about something that the court will make you swear about, something that you have to swear about, if you're swearing anyway, then we can include megalgel. We can include other vows while we're at it. Another matter, hey, I want you to swear about that too, since you're swearing anyway. So the claimant here, he really wants to make the defendant swear about some other matter where it's a whole value, not modeh b'miksat, or some other thing about land, whatever it is. But he's making this ruse to say, I'm going to claim 200 so that I know really he only owes 100. So he's going to certainly say, no, I only owe you 100. And then he will have to make a vow. Since he's making a vow, said, make a vow about that other matter also. No, you can't do that because midevar sheket tirchak. The claimant is actually making a lie. He's claiming 200, even though he knows full well that's only 100. So even if he has a purpose in mind that is just because he is owed something else and he wants to try to collect that and make a vow, and maybe if he makes a vow, then he'll pay. So even if it's true, that other part that he owes some other money from something else, still you can't tell a lie in order to get to the truth somewhere else. This is the same as the previous case, but now from the defendant's point of view. So it asks, how do you know that if someone claims 200 against you and really you only owe 100? How do you know that you shouldn't say, I owe you 0 in betin? In betin you say, I owe you 0. And then when you leave betin, you say, listen, I know I really owe you 100. Here, I'll pay you the 100. Why would he do that? Because he doesn't want to make a vow. He doesn't want to be modeh b'miksat, because if he says in court I owe you 100, he's going to have to make a vow. And once he makes a vow, then he knows that the claimant will add on other vows about other things, and he doesn't want to make vows about other things. And so he's in court, he'll say, I owe you 0, and then outside of court, he'll say, yes, I really owe you 100, and he'll pay him. So he thinks, well, I'm being honest because I'm going to pay him eventually. I'm just saying I don't owe you anything now in court so that I don't have to get into other trouble about some other vow that he's going to make me take. So you should not do that, because stay away from a false matter. Even though your intention is to pay him later, still you can't make a false claim now and say I owe you 0. How do you know that if 3 people are seeking payment from one person and altogether it adds up to 100 dinar? So you have one guy and he owes 33 dinar to Mr. A, to 33 to B, and 33 to C. Now, each of these 3 people, they have a right to bring this guy to court. But let's say they don't have witnesses, they don't have full proof that he owes them. So they want to come up with a strategy. And they say, here's what we'll do. We'll have one, Mr. A will claim 100, that the defendant owes him all 100. And the other two, B and C, they will come and act as witnesses. Now really, he doesn't owe A 100, but that's their plan, is that once you get paid Mr. A, then you'll give us the other 33 and the other 33, and that way we'll all get what's coming to us. So really, he does owe it all to us. So we're doing something that in the end will be truthful, but we're going to use a dishonest ruse and say that he owes one person so that the other two people can present themselves as witnesses. Well, you can't do that because it's still a false matter. You're coming to court and saying he owes A 100. He doesn't owe A 100. So you have to distance yourself from a false matter, and you can't do this. Minayin l'shnayim sheba'u ledin, echad lebush smartutin ve'echad lebush itz talit bat me'a maneh, shomrim lo debosh kamohu kemoto o halbishehu kemotcha tamud lomar b'davar sheker tilhak. How do you know that if you have two people coming to Beit Din as litigants, and one is poor person wearing rags, and the other person is wearing a garment worth 100 times 100 dinar, a very exquisite, very expensive garment, the judges can tell the person who's wearing the expensive garment, listen, either you dress like him in rags, or if you really want to dress the way you are, you have to pay for him to have a suit just like yours. Because you have to look, both litigants have to look equally presentable. The way a litigant looks in court, the way he dresses, makes an important impact on the judge. That's why today, every criminal in court, they come, they wear a suit and tie, nice tailored, right? Because if they come in ripped sweatpants and a ripped t-shirt, it looks like a criminal. When come in a nice suit, then he looks innocent. Okay, so then the looks definitely have an impact on the judge. And so therefore, it's only fair that both litigants should be dressed equally nice or equally disheveled. And so the judges can impose on the rich guy, listen, you want to dress nice, that's fine, but you have to pay for clothing for the other guy to dress just the same as you. And again, not that this is actually a lie, that the judge is going to favor a person just because he's well dressed, but you have to stay away from a false matter, and don't even let dress possibly influence you as a judge, and therefore you can demand that the litigants dress the same. When people would come to Rav Huna for judgment, he would say, take off your fine shoes and come down for judgment. I don't want people wearing fancy shoes. Here's an example of a nice fancy shoe from olden times, and so that will be more imposing, and the other guy will feel bad. He'll feel like he's disheveled, and he'll feel like the judge will have favoritism, so he would make people take off their shoes so that they would look the same. How do you know that a judge should not listen to one side, one litigant, before the other one comes into court? Because it says you should keep away from false matter. If you're going to hear one side first, then the judge might be influenced to take his side because he's hearing that first, and the other guy is not there to defend himself, to hear what happened and say, oh no, what he just said isn't true, and look, I have proof. So if he's hearing only from one side separately, it looks like he's showing favor to that side. Even if he's not, even if he'll then repeat it again and hear it from and hear the other side, but you have to stay far from false matter, and don't even look like you're planning something with one. This is the same law as the previous one, but the previous one was regarding the judge. Here, this prohibition is regarding the litigant. How do you know that a litigant should not explain to a judge his case before the other litigant shows up? Stay away. Then no one should look at the litigant and say, oh, look, see, you were talking to the judge beforehand. What are you trying to butter him up? You're trying to get your case, your case in his mind first? That's not proper. Rav Kahana matne lo tisa lo tasi. Rav Kahana explained the same rule, but he learned it from a different pasuk, from this pasuk here that says lo tisa shema. Do not carry a false rumor, and he read it instead of otisa, don't carry, lo tasi, do not cause others to accept a false report, and if he would speak to the judge beforehand, he would be causing the judge, or trying to cause the judge, to accept his one side, even though the other side was not there at the same time to counter it. And so that would be trying to relay a false report. ואשר לא טוב עשה בתוך עמיו, רב אמר זה הבא בהרשעה, ושמואל אמר זה לוקח שדה שיש עליה עסיקין. And now another pasuk that also tells us other things that one should not do. Not that they're directly stealing or lying, but that they're related to it. Pasuk says, and did that which is not good among his people. This is Yechezkel 18, when he says that only a son who does bad himself will get punished, and a son who does good, even if his father's bad, will not get punished. So he gives examples of people doing good and bad, and one of them is, and did that which is not good among the people. What do you mean among the people? What would be such a thing? So Rav says this is someone who comes to court with authorization. In other words, he doesn't come to court himself. He sends a representative, a lawyer, maybe a hired lawyer. So someone comes to court as an authorized representative of someone else. We don't want that. We don't want to have people just being represented by lawyers in court. In halacha, the rabbis wanted the litigants themselves to be in court and to represent themselves. That way, the judges will be impartial and ask them questions and discuss with them directly, and they could get at the truth better than if you hire professional lawyers, because then what often happens, as happens today, is if one side is rich and can hire a top lawyer who's a smooth talker and knows how to find precedents and build an argument and be more convincing, and the other guy can't afford a lawyer, and he guy has a guy who's barely trained at all, and so then someone might win just because they're paying more. And so lawyers have a way of obscuring the truth because of their training, and that's their job, you understand. But if the system allows for that, then it's going to have all the problems that come with having paid lawyers. And the rabbis knew that system very well, because that's how Romans worked. And so they said, we don't want courts that look like Roman courts, because they saw all the problems with that. And therefore the rabbi said, no, we don't want to have lawyers and someone, unless of course we saw earlier, if there's a woman who's involved and she feels too immodest to come to court, or someone who lives far away, for whatever reason they can't come, okay, then it makes sense. You can appoint a representative. So there is such thing as a representative, but someone who's coming not because of those reasons, but rather just to be the better lawyer, this is not proper. Lo tov asa betoch amav. Even though technically it's not lying, it's not that it's they're saying anything false, but still it doesn't lead to honest outcomes like the litigant themselves being there. Shemuel has a different application. There's someone who buys a field that has a contest of ownership over it. You have a field and it's already in court. There's people fighting about this. I was here. And then you go and buy that field. Now you're involving yourself in a dispute that wasn't yours, but now I want to be involved in a dispute, and now you're going to come and start bringing people to court. So don't involve yourself in someone else's problems. And that's really the same as Rav, where it's not your case and you're coming to represent someone else, so you're involving yourself in someone else's case. Let them deal with their case themselves. Don't go get involved and make things worse. Now back to the Mishnah. It said Shevuot ha'edut only applies to people who are fit to testify. Only if you can testify, then if you make an oath and say, I have no testimony, I don't know anything about it, and you're lying, then you have to bring a korban. But if someone is not fit to testify in the first place, then the whole law of Shevuot ha'edut does not apply to them. La pokemai, what does that come to exclude? Because it already said in the Mishnah, man and not woman, and so on. So what's this part of the Mishnah? Who is it excluding? Amar papa la pokem melech, v'ravacha bar Yaakov amar la pokem mesachek bekubya. The Papa says it's coming to exclude a king. A king, even though he might be very trustworthy and honest and not a relative or anything, but the king is considered beneath his honor to have to come to court and testify. He's not judged, and he doesn't serve as a witness. And so that's what it's talking about. If a king would make an oath and say, I have no testimony, I don't know anything about this, and he would be lying, he would not bring a korban. Ravacha bar Yaakov, however, says it's talking about excluding someone who is a dice player, a gambler, who is by rabbinic law cannot be a witness and therefore would be exempt from Shevuot ha'edut. Manda amar mesach bekobia kol sheken melech, umanda amar melech ava mesach bekobia medoraita machaza chazi v'rabanan hu difsaluhu. The opinion that says a gambler is exempt from Shevuot ha'edut would certainly say that a king is exempt from Shevuot ha'edut, because a king is exempt from testifying, so he also is exempt from Shevuot ha'edut. So if a gambler is exempt, he would agree that the king is exempt. He wanted to say even a gambler. So that's the opinion of Rav Acha bar Yaakov. Now Rav Papa, who said a king, he would say a king is exempt only, but a gambler is not exempt. A gambler would be liable if he made a Shevuot ha'edut and was lying. Why? Because a gambler, technically from the Torah law, is fit to testify. It's only the rabbis that came and said, we don't want gamblers testifying, either because it's like they're stealing. They're not actually stealing, taking money from someone, but the other person didn't fully, when he was made the bet, he thought he was going to win and didn't fully agree to give the money over, and now the other guy's taking the money, so it's like stealing. Or the other reason, because he's not involved in bettering the world. You're just wasting your time gambling, changing money from here to there, but you're not being a productive member of society. So for whatever reason, we don't trust this person, and the rabbi said he cannot be a valid witness. But on the Deoraita level, even a gambler can be a valid witness, and therefore the Shevuot ha'edut follows the Torah law. Since he could be a witness, if he lies and says, I don't know testimony, then he is liable. So Rav Papa, who says that a king is excluded, would say only a king is excluded, but a gambler would be liable for Shevuot ha'edut. Bifnei betin v'shelo bifnei betin v'chule b'mai kami palge. The Mishnah taught that Shevuot ha'edut, there's an argument about it. Everybody agrees that if you make a Shevuot ha'edut in court and you lie, then you are liable, whether you made the vow yourself or someone administered it to you. That everyone is in agreement with. Everyone also agrees that if you make such a vow outside of court and you don't make it yourself, it's administered to you, someone administers the vow outside of court, it's not valid, not liable. The machloket, however, is if you say the vow yourself, outside of the courtroom. According to the Meir, you are liable. You said it yourself. According to the Rabbanan, you are not liable because it's outside of court. Rabbanan say it only applies in court. Now, what is the essence of their machloket? Amaru harabanan kamed Rav Papa. Bedon mina umina. Bedon mina ve'okeh. But be'atra kami palge. So the rabbis said before Rav Papa, the rabbis proposed the following explanation in front of Rav Papa. Rav Papa is going to disagree with these sages, his colleagues, or maybe his students, and give a different explanation. But this is the explanation that the rabbis proposed to Rav Papa, that they learned it from a gezer hashava between Shevuot ha'edut and Shevuot pikadon. And they're arguing about when you make a gezer hashava, so basically it's a copy and paste. You're taking a law that it says in context A, and you're copying and pasting it to context B. But the question is, when you copy and paste, are you copying and pasting with the formatting of the original in word terminology? Copy and paste with original formatting and put the whole thing as it was in the original, put it in the new place? Or are you going to copy and paste with local formatting where you're taking some of the basic idea from the source, but then when you paste it in, exactly how you make it work with all the other laws is you look at the local context of where you're putting it into, and you derive there. So that's what it means here. Bedon mina mina. That means you derive from it and everything that's part of it, the context of the source. You learn everything. Whereas don mina ve'okeh be'atra, you learn something from the source, but then you make it fit into the destination. That's what they're arguing about. Now, what does this have to do with Shevuot Pikadon? So here's Shevuot ha'edut. It says, "V'nefesh k'tarav l'shema kol ala v'hu ed o ra'a o yada im lo yagid v'nasa avono." So if someone knows testimony, he has to say so. If he lies falsely about it, he is liable. And here it says the phrase "shame'a kol ala." He heard an oath, meaning someone else said, do you swear? And he said, yes, I swear. So that is being administered by someone else. So regarding Shevuot HaEdut, we know that administration by someone else is going to be valid, at least in some context, in the context of within the court. Now, later on in that same perek, it talks about Shevuot HaPikadon. Ashak oat HaPikadon, asher avkadito, and someone says, hey, I gave you this thing, and where is it? He says, I don't have it anymore. So he has to swear that he did not take it himself, that he was not negligent. So this kind of vow, Shevuot HaPikadon, it says, O mikol asher yishaba alav lasheker, if he lies falsely. Really, he stole it himself, and he lied and said, oh, it was stolen, someone else took it. So here it says, Asher Yishaba alav, meaning that he makes a vow himself. So regarding Shevuot HaPikadon, it says he makes a vow himself. In Shevuot HaEdut, it says someone else administers the vow. So now we're going to make a Gezerah Shavah so we can learn one to the other. And this is how it will the machloket will work. Rabbi Meir Savar. Rabbi Meir again said that you are liable even if you're outside of court, as long as you said it yourself. He says, Don mina umina. So he would say, learn, so, yes. So the Bimei says that you learn the entire thing as the origin was. Me pikadon, ma pikadon mushpa mepi atzmo chayav, at afedut mushpa pi atzmo chayav. Just like regarding pikadon, it says there in that pasuk that if you swear yourself, you're liable. So that's the source. We're going to learn a gezerah shavah, and in the destination, one is liable if you said the vow by yourself. So that's why there's got to be a case where you are liable when you said the vow by yourself. Now, that's the general derivation. That's the copy and paste, the basic copy and paste. But how actually are you going to apply it? In what cases are you liable when you vow yourself? Only in court or outside of court? Umina ma pikadon ben bebetin ben shelo bebetin af edut ben bebetin ben shelo bebetin. So we're going to derive it from the source. Just like in pikadon, you are liable whether you make a vow in betin or outside of betin, and you say, "Oh, I don't have the item; it was stolen. I don't have it." So whether you make that in betin or betin, you're liable. So we copy and paste with the origin formatting. And we say, so too regarding Shevuot HaEdut, whether it's in betin or outside of betin, if you made the vow yourself, you are liable. That's the source of Rabbi Meir. But Rabbanan say, yeah, we're going to derive something from Pikadon, but not the full context of Pikadon. Ma Pikadon mushma pi atzmo chayav, af edut mushma pi atzmo chayav. Yes, just like Pikadon, if you swear yourself, you're liable. So too, there is a case in Shevuot HaEdut where, when you make the vow yourself, you are going to be liable. But which case? So just like if someone else administers the oath, that's only valid in betin, but not outside of betin. That's the local rule. So too, the rule that we're deriving, which is when you make the vow yourself, we're going to apply it with the local formatting, which is that it only applies when it's done in betin and not outside of betin. And that's how the rabbis derive that one is liable in court, no matter if you make it yourself or administered by others. But outside of court, no, there's no such thing. There's no valid Shevuot HaEdut. So that's what the rabbis proposed to Rav Papa. Amal hu Rav Papa, even pikadon gamri la Rabbanan, dekula amala plige de don mina mina. Rav Papa says, no, I don't accept that explanation. If you're going to learn something from Pikadon, then everyone will agree that once you open that channel and derive it from there, then you're going to derive the whole thing, and you would agree in the end with Rabbi Meir that you derive the whole thing, and just like in Pikadon, it works even outside of court. So to Shevuot HaEdut, if you make the vow by yourself, it's going to work even outside of Bet Din. So if you're going to use Pikadon, then you have to use it for everything. So that would work for Rabbi Meir, but not for Rabbanan. Rabbanan are not going to learn from this Gezerah Shavah at all. At least they don't need to. The rabbi is going to learn a kal vachomer from within Shevuot HaEdut itself. If someone else administers the oath to you, you're liable. So all the more so if you make the vow yourself. If you make it yourself, isn't that more responsible, more liable? But there's a rule when you learn something kavachomer that you can't derive more than the origin, and you can't apply it further than the source that you're learning it from. So the source you're learning from is when someone else administers the oath. Well, that only works in Bet Din, but not outside of Bet Din. Everybody agrees to that. So too, what we're going to learn from it is regarding swearing oneself. Good, you can learn a kavachomer, but dayo. So you can only learn that if you swear in court, then you're liable, just like administering an oath to you is liable in court, but you can't learn outside of court where the source administering an oath is not valid outside of court, so the kavachomer cannot be applied outside of court. And so the Papa says, Rabbi Meir will agree with the Gezerah Shava and learn the entire thing, everything from it. Rabbanan will learn from a kavachomer from within Shevuot HaEdut itself and will not use the Gezerah Shava. Amru le Rabbanan le Papa, mima set amat la bedon mina umina palige. So the rabbis respond to the Papa and say, can you really say that Rabbanan and Rabbi Meir are not arguing about this principle of whether when you have a Gezerah Shava and you copy and paste, you copy from the original formatting, you copy everything, or you just copy one thing but you use the local formatting and when you apply it? You really think that they're not arguing about this? We will prove now in the other direction that this is the only way to explain Rabbi Meir and the rabbis when it comes to the laws of Shevuot HaPikadon, v'hatenan, gabe Pikadon. Shevuot HaPikadon noheget b'anashim u'b'nashim, b'rechokin u'b'krobin, b'keshrim u'pesulin, b'fnei beit din v'shelo beit din, mepnei atzmo pnei acharim, eno chayav ad shechpor bo bebeit din divrei Rabbi Meir. The Mishnah teaches regarding Shevuot HaPikadon that it applies both for men and women. A woman can be a custodian to watch something, and then it could get lost, and she would have to make a vow. And it doesn't matter whether it's a relative or not a relative, whether someone is who can be kosher as a witness or not invalid as a witness. And this applies both in Bet Din and outside of Bet Din if he makes the vow himself. However, if others adjudicate the vow, administer the vow to him, then that's only in Bet Din, according to Rabbi Meir. According to Rabbi Meir, therefore, the rules of Shevuot HaEdut and Shevuot HaPikadon are the same. This is exactly the same as what we just saw. Hachamim omrim ben mepi asmo ben mepi acharim kevan shekafar bo chayav. Hachamim, however, are different. They said when it comes to Shevuot HaPikadon, it doesn't matter whether he said it himself or others administered it, and it doesn't matter whether it's in Bet Din or outside of Bet Din. All cases, one is liable. If you made a Shevuot HaPikadon and you said, I don't have it, it's not my fault, and then you're lying, you really kept it the whole time, then you are liable according to Chachamim. Now, what is the reason for their machloket? Mushpa mepi acherim bepikadon mina lehut labana dechayav lav degemiri la me'edut ushma mina bedon mina umina pelige. Now, if someone administers the oath regarding Shevuot HaPikadon, the fact that one is liable according to Rabbanan, whether inside of court or even outside of court, where do the rabbis get this from? Aren't they deriving it from Shevuot HaEdut? And obviously, if that's their source, they could only derive their law if they're using the Don Mina Umina Pelige. As we mentioned above, that only regarding Shevuot HaEdut, that's where it has the phrase that says if others make the oath and you hear it. So that's other people administering the oath. So now we know that there's a case where other people administering the oath that applies, that was said by Shevuot HaEdut. We're going to transfer that over and paste it onto Shevuot HaPikadon. Now, when we paste it, what cases are we going to paste it to? According to Rabbanan, they're pasting it onto every law. Well, they can only do that if they're using the local formatting and explaining that just like in Shevuot HaPikadon, when you make the vow yourself, it doesn't matter whether it's in court or outside of court. So too, we're going to use that local principle and apply the case of others administering the oath to you and say you're liable both inside of court and outside of court. That makes sense. That would be their derivation. Whereas Rabbi Meir would say, no, I'm also using this Gezerah Shava. I'm going to learn that in Shevuot HaEdut, there's a case of administering an oath. That's one that's liable. Now, when I come to paste it over here, I'm going to say, wait, where can I paste it? Can I paste it in all cases? No, I can't, because in the local scenario of Shevuot HaPikadon, it doesn't apply to all cases. I can only apply it to the scenario that it applied to in the source, because Bimir says I have to use the source formatting, and just like in the source, which is Shevuot Ha'edut, the administering an oath by others only applies in court, so too when I copy and paste it onto Shevuot HaPikadon, it's only going to apply to the same one case from the source, which is only in court but not outside of court, and that would explain how the Meir got his view and Abanan got their view. And so you see that they are in fact arguing with this methodological principle. That's what the rabbis told Papa. So how can you say that they're not arguing on this methodological principle? Papa answers, Mahi'in Meha Leka Mishma Mina. Rapa says, I agree with you regarding that Mishnah. If you're going in that direction from Shevuot Ha'edut to Shevuot HaPikadon, then that's the only way to explain their machloket in Shevuot HaPikadon. So yes, that is a proof. But the first thing you said, which was you tried to prove it in the other direction, that is not a proof. So yes, I agree that this is a proof. What you said before was not necessarily a proof. I was able to explain their machloket in Shevuot Ha'edut using a kal vachomer and not based on that methodology. But you're right. Now that you show it in this way, yes, they must be arguing about the methodology. So now you've proven it. But my point before was simply that the previous Mishnah itself did not prove the point. V'chayavin al zedon ha-shevuah. The Mishnah continues and explains that regarding Shevuot Ha'edut is different from most other korban chatats, where Shevuot Ha'edut one is liable to bring a korban specifically when one does it b'mezid. When I know that I actually do know testimony, and I know I'm not supposed to swear and say I don't know testimony. I know it's not allowed, and I know that that will trigger a korban, and I do it anyway. That's when I have to bring a korban. What's the source? The Baraita explains, but because in Vayikra, in that chapter, when it's talking about other korban olev yoreds, for all the other cases, when he doesn't know, he forgot about something, and then he makes a mistake, and he sins, and then he realizes, so then he brings a korban olev yored. That's true for all the other cases, but for Shevuot Ha'edut, it doesn't say the word v'ne'alam, which means that one is liable when one knows perfectly well that this is he knows that he has testimony, he knows he's not allowed to lie and swear falsely about it, and he knows that there'll be a punishment for it. In that case, that's when he actually does bring a korban. The Mishnah says not only if he knows everything, that's totally b'mezid, but also when he has a shogeg regarding the vow, but it's zedon regarding the testimony. What does that mean? That some of it is shogeg, some of it is b'mezid. Amar Rav Yehuda Amar Rab be'omer yodei ani sheshva zo asura, aval eni yodei im chayavin aleh korban im lo. When he says, I know it's prohibited to do this. That's the zedon part. I remember the testimony. I know the testimony, and I know that I'm not allowed to swear falsely. So yes, that's the mezid. But what I didn't know is whether I would have to bring a korban or not, and that I didn't know. So that's the shogeg part, and that also that's the same as total mezid. One has to bring a korban. Ven chayavin al shigata giradata lema tanena lidrav kahana udrav aseh. Now in Shevuot Ha'edut, if you don't know anything at all, you forgot that you forgot that you witnessed that thing, and so when you said, I swear I don't know anything to any testimony about this matter, when you said to swear, you thought you were telling the truth because you really forgot what you had seen. In that case, you're not liable to bring any korban. Should we consider this a source for the story of Rav Kahana and Rav Aseh? If you remember, back a few dapim ago, Rav Kahana and Rav Aseh were both students of Rav. And Rav taught a class, and afterwards Rav Kahana said, I heard him say A. Rav Aseh says, no, I heard him say B. And they both swore, I swear I heard him say A. Other says, I swear I heard him say B. Then they went to Rav and says, okay, what did you actually say? And he said, I said A. So now, what about the other one who said, I swear I heard him say B? Is he now going to be liable for making a false swear? Shevuot sheker? So Rav says, no, when you said that, you really thought you were saying the truth, so therefore, you're not liable. So maybe there's a source where, if you really think that you didn't know testimony, and you swore, then you're not liable, because that's a shogeg, that's totally not liable. Maybe that's the same thing here, and so we have a source for Rav's ruling there. And we say, no, la afa gav ditnan istirich. No, even though we have this Mishnah, Rav still needed to teach us this. We couldn't have derived it from the Mishnah. Rav was not telling us something redundant that we could have figured out ourselves. But because this Mishnah is not exactly this case, there are two different types of Shevuot. I might have thought, without Rav teaching us that you don't have to bring Korban in that case, I might have thought that only regarding Shevuot Edut, where it doesn't say the word V'nei Elam, since it doesn't say V'nei Elam, what's the case? In order for something to be shogeg and liable, has to be similar to mezid. So the case of shogeg that one is liable in is when I knew testimony, and the only thing I didn't know was what the punishment is. I didn't know if you have to bring a korban. So that's shogeg that's similar to mezid. In that case, shogeg has to be similar to mezid, and if you didn't know anything at all, no punishment, because it doesn't say the word V'nei Elam. But regarding a false swear, where it says the word V'nei Elam, there I might have thought that even if someone forgot totally, they thought that they were swearing the truth, and they forgot totally what Rav actually said. He really thought that Rav said B, even though Rav said A. So I might have thought that he is liable, because it says the word V'nei Elam, and so I might think that shogeg there means any type of shogeg, even if you forgot everything totally and you thought you were telling the truth, you'd be liable. That's why Rav has to come in and teach. Not so. If you made the vow thinking that it was totally true, then you also are not liable in that case. And so that's why we needed the story of Rav to teach me that chidush. The next Mishnah teaches Shevuot Ha'edut Kesad. What's an example of Shevuot Ha'edut? Amar l'shnayim bo v'ha'iduni Shevuah she'en anu yodim lecha edut. One example is someone says to two people, come and testify for me. You have testimony about my case. And the witnesses say, we make an oath, we don't know anything about your case. We have no testimony regarding you. That's a case where one makes a vow for oneself. Or shamru lo en ani yodim lecha edut mashpi ani alechem emru amen hare elu chayavin. Or if the witnesses say, we have no testimony about your case, and then someone says to them, I make you swear. Do you swear to that? And they say, yes, amen. So that's an oath being administered by other people. That also would be chayav. We talked before, it depends on if it's in betin or not betin, depending on who you follow. But that's the basic case. Let's say someone made a vow 5 times outside of Bet Din. We don't know anything. And then they came to Bet Din and they admitted, yes, we know something. Then all those vows, they're not liable. They never violated the vow. Although they said we don't know anything, they never denied it in court. And in court, that's where the denial matters. Denying something outside of court is not yet a denial until it's denied in court. And so therefore, piturin, those vows didn't mean anything. Kafru, chayavin al kol achat ve'achat. However, if they made 5 vows outside of court that they don't know anything, and then they came to court and they denied that they know anything, but they really do know something, then they are liable for each and every one of the vows that they made outside of court. In other words, once they deny it in court, then those vows do come into effect. So a denial only outside of court, but then they come to court and admitted it. Okay, so you totally admitted it. Whatever you said outside of court, you came to court and you said the testimony. That's okay. But once you say in court that you don't know anything, then you're fulfilling, you're enacting those vows, and all those vows then are applicable, and you're liable to each and every one of them. Now here's a paradox. If the Bet Din administered 5 oaths in front of the guy and the witness said each time, no, we don't know anything, and then it turns out that they were lying, they only are liable for 1 korban, only for the first oath that they made. Well, that's curious. Why is that? When they were outside of court and then they came to court and denied, they're liable 5 times, but when they made the oaths in court, shouldn't that be even worse? Amar Rabbi Shimon, ma ta'am, ho'il ve'nam yecholin lachazor ulhorot. Rabbi Shimon explains it's because once they say in court that we don't have any testimony, there's a rule that you can't retract. Witnesses cannot retract what they said. Once witnesses say something, they can't retract and say we changed our mind, because we assume that actually maybe they were telling the truth the first time. Let's say they said, "Oh, this guy murdered." Yeah, so they testify, and then after that, oh no, now they're going to kill the guy based on my testimony. I take it back. I don't want it. So you can't retract testimony. Once they say we don't know anything, then they cannot testify any further. Since they cannot testify at all after the first time that they deny that they know any testimony, so now they're invalid witnesses regarding this matter. So the second, third, fourth, fifth oath that they make is not valid because they could not have testified anyway. Only the first one is the one that matters, and therefore they're liable only once. If you have two witnesses and both of them at the same time say, we don't know anything, and it turns out that they do know something, they are liable for testifying otherwise, for making an oath otherwise. However, if first one of the witnesses says, I don't know anything, and then the other witness makes an oath and says, I don't know anything, then only the first is liable for a korban, because only before, when they first came in, they were eligible to be witnesses. There's two valid witnesses. When the first one says, I don't know anything, then the other one is useless, because without two witnesses, one witness can't do anything. So the single second witness is useless anyway, since he cannot make a valid testimony. So his denial by oath is also not important, and he is not liable. Kafar echad v'oda echat, hakofer hayav. If you have two witnesses, one denied and one said, yes, I do know, then the one who denied is liable. That seems to be a repetition of this law. The Gemara will discuss what else it's adding by saying this line. Hayu shetechi te'edim, kafra rishona v'achar kach kafra sheniya, shetehen chayavot, mipnei sheha'edut yechola litkayim b'shtehen. If you have two sets of witnesses, four witnesses altogether, two and two, and then the first two witnesses come and say, make an oath, we don't know any testimony. And then the second witnesses say, make an oath, we don't know any testimony. And it turns out that they both do know testimony. Both of them are liable in this case, because the second set could have testified even without the first. The fact that the first set said that they don't know anything, that doesn't disqualify the second set. So this is different from when you have only two witnesses and one says, I don't know anything. Well, then the second witness can't testify by himself. But when there's two sets of witnesses, then the second set can testify by themselves, and therefore the second set will also be liable. Baruch Adonai Le'olam, Amen ve'amen.